Good morning, everybody, and welcome to our 2024 Virtual HOA Condo Academy class. Our April class for 2024. So glad that all of you could join us today. We're going to be talking about navigating stormy waters and handling difficult people and situations in HOAs and condos today. So in this session, well, first, good morning to everybody. Thanks for being here today. And welcome to class number 4 of our firm's 2024 Virtual HOA Condo Academy. We teach this Condo Academy, HOA and Condo Academy, in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Surprise, and Tempe. My name is Beth Mulcahy, and I'm the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I have enjoyed representing HOAs and condominiums for the past 27 years. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. And I also serve on my HOA board and have for many years. Before we get started, I always like to know who's in my audience this morning. So I'd like to do a quick poll to find out who's here. Looks like right now we already have, wow, that's amazing. We have 136 people on Zoom. So welcome, everybody. Thanks for being here. We just launched our 2 polls, so it would be really helpful for me to tailor the class best to the viewers this morning. If you could answer the questions. If you're joining us on Facebook Live, which we know we have a number of you also joining us on Facebook Live, the 2 questions that we just need you to answer in the comment section are: which city do you reside, or which city is your association in Arizona? And let us know your current role with the association. Are you a board member? Are you a homeowner that's not a board member? Are you a manager? Are you just interested in this topic and neither a board member or a HOA member? We'll go back to those poll results in just a minute. First, let's talk about what we're going to be talking about today, our agenda. Today, I'm first going to start out and talk just for a very brief minute about the HOA and condo bills that have been introduced this year in the Arizona legislature, and also give you a summary, a very quick, brief summary of the 5 bills that have been signed by the governor and the 1 bill that's sitting on the governor's desk right now in Arizona. After we get through the brief legislative discussion, I'm going to talk a little bit about what are some tips on how to deal with difficult situations in an association, and then how to handle difficult owners. And we'll also cover removal of a board member and how associations should respond if that happens. And if you're a homeowner that's listening in today, you want to know how to remove a board member from office, we'll be talking about that. We're going to be talking about code of conduct. And we're also going to be talking about the sticky situation of fraud and embezzlement in associations. So we have a lot of topics to cover today. Let's see who's in attendance today. So we've got our poll results in. It looks like in terms of the cities who are represented here today, we have 12% from the city of Chandler, 3% from Glendale, 3% from Goodyear, 25% from Mesa. Wow, that's amazing. Thank you, everybody, for being here. 4% from Peoria, 21% from Phoenix, 19% from Scottsdale, 6% from Surprise, and 6% from Tempe. So amazing, diverse group that's here with us today. So thank you for being here. Our second question is, what is your current role with the association? So 67% of you are board members here today. We have 9% that are managers, 23% that are interested homeowners, and 1% that's in the other category. So looks like we have a strong representation of board members and, a good number of homeowners as well. And great to see the community managers here as well today. So thank you, everybody, for giving me that feedback so I can tailor our presentation today to, the majority of the participants and cover everybody. Okay, let's talk about what's going on in the legislature right now in Arizona. The legislature has been in session since the 2nd week in January of 2024. This has been a huge year in terms of a lot of bills were introduced this year that pertain to associations. Some of them were duplicative, so some of them were very similar. As of right now, we have 5 bills that have been signed by the governor that pertain to associations, and 1 bill that's sitting on the governor's desk right now. A couple of thoughts, just so we know the timeline on this. The bills that have been signed by the governor and have become law They won't actually be effective until 90 days after the legislative session ends, unless the bill specifies a different effective date. So we have a lot of time here to learn more about these bills because the legislature is currently in session. They're moving pretty slow in terms of passing the budget. And typically, in my experience of following the legislation for the past quarter of a century, is that what typically happens is once the budget is passed for 2025, what will happen is it'll be like a 50-yard dash to end the legislative session. And so it's possible that there could be a few more bills in that period, or maybe a few more bills in the next few weeks. But right now we have 5 bills that have been signed by the governor and will become effective 90 days after the legislative session ends. If I had to guess, just based upon how things are moving, I would anticipate that the legislature will adjourn by June 1st. And then that will put us in the timeline of, June, July, August, probably sometime in late August or September. All of these bills will be going into law. You can guarantee that our firm is going to be talking about all of these bills extensively over the next few months just to get you prepared for them. We're going to be sharing with you right now. We just have a little cheat sheet that's not a deep dive by any means on all the bills that have been passed, but just a quick, summary if you're just interested in what's going on. And we'll be talking more and more as, the legislature closes up its session, and then we have an actual effective date to educate everybody about what bills we need to be aware of and what bills became the law this year. Okay, so we're going to be sharing our 2024 legislative summary with you shortly if we haven't already. And again, that's just a very quick overview of the bills that have been signed by the governor and the ones that we're still watching this legislative session. Okay, let's talk about our first topic. This is actually a topic that honestly kind of keeps our firm in business. It's dealing with difficult people and harassment. Unfortunately, if you just Google HOAs and, difficult people or harassment or whatever, you're going to get a lot of hits in terms of there's a lot of news stories pertaining to problems between association members, between each other, problems between the board and members, inter-board problems. It's a very common theme that, that there are difficult issues that pertain to associations. And sometimes when we have difficult people that are handling these issues, it escalates everything. So let's talk a little bit about how do we handle, difficult situations during a board meeting. And so I think the first thing is we need to have some ground rules at a board meeting. And I've been doing this so long that I have some kind of good war stories about, different things that have happened over the years. But one thing that I just kind of remember from my past that just kind of stuck with me was I remember being with one of my kids going to like a kindergarten or preschool classroom, and they had all these classroom rules on the wall. And they were like, no name calling, no shouting, no pushing. And honestly, it's very similar for associations. I think it's important that if your meetings are not functioning well, that your board consider adopting, some rules on how to have, a productive meeting. And so one way to limit conflict during a meeting would be to have some rules that say, okay, no name calling, no raised voices, no interrupting of other people during the meeting, no personal attacks should be allowed. And this could be between the board members or between a board member and a homeowner. And we know that, if board members aren't getting along, it really can bring productivity and getting things done for your community to an absolute halt because you're just dealing with interpersonal conflict all the time. And so, a couple things that we recommend if you're in that situation. So first thing, consider having a boot camp where you bring in an expert. And our firm does this for associations. We come to the board meeting and we have a boot camp and we talk about the problems that your board is having. Why are there conflicts? Why are people, interrupting meetings? Why is there so much animosity? Why, do our meetings last 6 hours? And we really I talk to all the stakeholders before I have the boot camp and hear everybody's, respective positions. And then I try to come in a boot camp and talk with the board about how we can manage the situation the best. And one thing that I typically will do is I will ask everybody to take the DISC, D-I-S-C, personality test. And the reason why I do that is it's really inexpensive and it's a great way to show everybody's differences. Everybody is different. That's what makes a board good. You can't have everybody be the same, right? And so there's different personality types on the board, and some people want to make decisions quickly and they get annoyed when, people are slow to make decisions and need more facts. Some people don't shy away from conflict, right? They like conflict. Other people, don't like any conflict. And so, that's another thing that the DISC personality test brings out. Some people are optimists and some people are pessimists, and that's just a reality, right? And so what I try to do is through the DISC test, everybody shares their results, and then we talk about how everybody's different and how having different personalities on the board can actually be a good thing because, the people that are really detail oriented, they can maybe slow down a little bit the people who want to make decisions too quickly. And it can be a good give and take on a board. And so that's one thing. Recognize that differences are not always a negative thing. It can be turned into a positive thing. So having a boot camp where we talk about these issues, we talk about what the biggest problems are in the association, and we brainstorm about how we can effectively manage the problems. And we maybe talk about things in the past that haven't gone well and how we can do better going forward. And we also, maybe that's a good time to lay out what would be some meeting rules going forward so that the interpersonal conflict is limited in the future. Some suggestions I have on how to limit the interboard conflicts would be make sure that you give all board members an opportunity to speak. Now, I'm not saying that, sometimes I go to a lot of meetings. So sometimes I see one board member trying to dominate the floor at the board meeting, right? And so maybe there's a topic that we have a motion and a second, and we're, discussing something before we take our formal vote. And, maybe we have one board member say something, and then, this particular board member, let's call him board member B, they say something, and then board member C says something, and then board member B wants to go back and say something else. And so what we try to do is just make it fair, right? Just let everybody on the board have an opportunity to say something once, with the time limit. If we've got people that take, a lot of time discussing things, maybe a minute per board member. And then if after everybody's had a chance to talk, if the board member B wants to say something again, then just say, okay, 30 seconds rebuttal, and then we're going to move forward. And that's a really effective way to make sure that we don't have one person dominating the meeting and that everybody has an opportunity to talk who's on the board who wants to talk. Another thing would be time limits. We talked a little bit about that. So if you've got somebody that goes on and on and on, that's a board member, just saying, okay, and the president does this. They just say, okay, we have an hour that we're going to have for this meeting. We're only going to spend 30-second comments or minute comments on this particular issue before we vote on it. And these are just some really good suggestions. We have a cheat sheet, just so you know, that deals with the difficult people and harassment that we're using kind of to help teach today. So if you want more of a deep dive on that, you can look at it. Another thing to limit board member conflict would be make sure that you educate new board members on board processes and what our outstanding issues are in the community. Sometimes you get new board members, and I know I was like this when I was elected to my board for the second time, was that, there were a lot of issues that I hadn't been involved in for, 8 or 9 years while I was off the board. And so it would have been nice if somebody had come to me, and preferably like the president, who should always be the conduit to bring people together, and said, okay, here's how we're handling things right now and these difficult situations in our board, and give me a little history on them, so that when I went into my first meeting, I was, teed up and ready to listen to the issues and be a productive board member. Another thing, encourage mentoring of new board members. It's frustrating to be on a board. That's a very common thing that I hear. I feel it. I've been on my board now for like 14 years collectively, and it can be tiring. But when you get a new board member who maybe isn't as familiar with the open meeting law or isn't familiar with the fact that we need to be transparent as a board and we need to share books and records if an association owner requests them. There are a few exceptions that we can't give to them under the books and records request, but for the most part, everything's fair game and owners can see it. So having a mentor on the board, preferably like the president or somebody who's had some tenure on the board for a long time, is a really helpful way to integrate the new board member into, okay, this is how the board is operating and this is why we have to do this, etc. Let's switch gears and talk a little bit about what do we do if we have a difficult owner. So now we're getting away from board member to board member conflict, right? And now we're moving to how do we deal with the difficult owner? And this is honestly where our firm becomes more involved. This is, like I said, this is a very common problem. And so typically what happens is, we call them a gadfly. And I didn't coin that term. I know I read it in a CAI book many years ago. And what is a gadfly? A gadfly is a difficult owner who is very outspoken regarding their views pertaining to the management of the association. Sometimes a gadfly is a former board member who's not happy with how things are being run after they left the board. Sometimes it's just a homeowner that's never been on the board, but maybe they lived in an association somewhere else, back in Michigan or Wisconsin, and things operated much better there, according to them. Or maybe this is their first time being in a board. So what does a gadfly typically do? They like to criticize. They like to pinpoint the errors of others. They demand change. But when you ask them to help with the change, they don't have time. They like to interrupt board meetings. They like to raise their voice, make threats. They attack the personal integrity of board members and the management company. And they allege conflicts of interest without any proof that there are conflicts of interest. So I don't know if this is ringing home with any of you here today, hearing about the gadfly. If it is, give me a little feedback, give me a thumbs up or something on Zoom, or, put a comment in there on the comment section, and same thing on Facebook Live. But from our experience, dealing with gadflies and difficult owners is probably one of the most challenging things for a board. And it often makes people get burned out. And it often takes our eye off the ball, which is the most important thing, is managing the association, maintaining the common areas, keeping our finances in order, and making sure that this is being run like a business. It can be very annoying and it can take a lot of time. So what do we do to handle the gadfly or the difficult owner? So here's some suggestions that we have that have worked over, a quarter of a century, and we've fine-tune these to help you navigate this problem. So first things, if you're having difficulty with the difficult owner coming into a board meeting and hijacking the meeting and yelling and screaming and, making comments out of turn and at inappropriate times, establish and announce meeting procedures at the beginning of the meeting. So this is how our meeting is going to be run, and collectively the board should make up these, meeting rules, so to speak. You might even want to publicize them on your website or in your newsletter. And then once you announce those meeting procedures, enforce them uniformly. So the first time somebody, violates the meeting rules, remind them that, hey, that's a violation of the meeting rules. If they continue to, be disrespectful and violate the meeting rules, then you can ask that person to leave. In my experience, they refuse to leave typically. And then we have, a difficult choice as a board. Is the situation so bad that we need to, take a break in the meeting? Or just cancel the meeting altogether? I don't know how bad the situation is, but some boards do that. And some boards do that to make a point too, that like, hey, this is not acceptable. We asked you to leave and you're not leaving, so we are not moving forward with this meeting. Now, obviously, that's not ideal because that means we're pushing off. We got to come for another meeting, right? A different night, which, it's a big time commitment. And secondly, we may just not even have a meeting that month, right? And then everything that we needed to move forward on, at our April board meeting is now being pushed to May. So it's prohibiting progress. So you got to balance that, the objective of making a point that like, hey, this is not acceptable. We're going to cancel this meeting with, the other side, which is, okay, now we're not getting a meeting done this month. But I have seen it used effectively, so I'm mentioning it as a possible tool. Another option is if they refuse to leave, you can contact the police. In theory, it sounds like, okay, well, contact the police. We've asked this person to leave. This is private property. They're refusing to leave. But in, practice, what I've found on this is most times the police will come and they don't want to get involved in an HOA or condo dispute. And so they will listen, but they're not going to do anything really. And it kind of puts them in an uncomfortable position because, they're not, an HOA dispute doesn't translate to, something that police is going to get involved in unless there's like some sort of like a assault or battery or the person has made threats, or something like that against the board. But it's something to keep in your back pocket if things are, really out of control and you think that's necessary. It's something that you can do, but just know that unless it rises to a certain level, typically the police they're not going to know, it's going to be one side versus the other side, and they're going to throw up their hands and say, I'm sorry, we can't get involved in this civil dispute. Okay, so if we're dealing with a difficult owner, we've talked about a couple things. We have meeting procedures. We enforce those meeting procedures through a couple of different ways. Another thing to do is sometimes the gadfly comes to the meeting and they just want to say something about what they're upset about, right? So what we recommend is have a homeowner forum at the beginning of the board meeting and put some time limits on it. So the board meeting opens, right? And then we have the homeowner forum at the beginning of the meeting. And we allow any homeowner that wants to say anything 1 minute, and the board will listen. And then we move into the regular board meeting where the homeowners aren't allowed to contribute unless the board is taking a vote or formal action on something. Then if the homeowner wants to contribute, they can contribute then during the discussion period with a time limit. I like having the homeowner forum at the beginning of the meeting, and here's why. Because if you've got somebody who's really upset about something, they come to the meeting, they tell you what they're upset about, and then oftentimes they leave. And, then you can actually get your business done. Also, it gives you an opportunity to limit, them from interrupting the meeting throughout the meeting because they've already had their opportunity to talk. Okay, another suggestion for dealing with difficult owners or the gadflies is establish control. And this really goes to the board president. So the board president, should make it clear that nobody should be interrupting board meetings by speaking out of turn or raising irrelevant issues or harassing board members, harassing other homeowners that might be at the meeting. And really, I mention this because the board president is like the point guard here. And the point guard needs to be in control of the meeting. And when the meeting is veering off course, sometimes I see board members bring a little gavel to the meeting, and that helps get things back on track. And just a reminder, have the board president again say these are the meeting rules and ask the person to leave if it's getting out of control. So just want to make it clear that the team captain here is the president, and they're the ones that should be establishing the control. And they need to do it in a modulated, non-argumentative way, right? And so typically, when you have somebody that's upset about something that comes to the meeting and they're yelling and angry and they're making allegations and insults, the board, just needs to listen. And if there's something that they can respond to, you do it in a calm, rational way. If the person is, maybe mentally unstable, or maybe they have their facts wrong, maybe you could say, can you stay after the meeting? And I'd like to have just a short discussion with you so I can show you some information that will counter what you're saying. But what you don't want to do is get into an arguing match or a yelling match with an owner at a board meeting. A, it's unprofessional. B, it shows a lack of control. It shows like, hey, we're not even running this like a business. This is, like the Jerry Springer show. We don't want that. And so the way to do that is to recognize, okay, we don't have to rebut every comment that a homeowner makes at the meeting. It is very okay to say, thank you for coming and thank you for your comments. And then you move on. Now, sometimes somebody will come to a meeting and they'll say, I think the board is taking Kit Kats from the tree trimmer. And, they have nothing to back it up with. what you may want to respond in that way would be, I'd like to talk with you about this after the meeting, so stay afterwards and I can, explain that that is inaccurate and why. If they claim that the board's stealing money, you can say, as a homeowner, you are entitled to review the books and records of the association. I think if you do that, you will see that that is a false statement. And, I encourage you to stop defaming the board or, we will take legal action, right? But you don't want to fight with them, okay? And so sometimes the best thing to do is to say nothing. Now, I know I'm on my board, and if somebody came to our meeting and accused me of fraud or something, I would definitely respond back because I don't want that just laying out there on the table and having me not say anything. But I think respond back in a way that shows that you are in control, that here's what you can do to verify that we are telling you the truth, and move on. Another thing to remember is use parliamentary control. Now, no association is required to follow Robert's Rules of Order unless it's in your bylaws, which if it is, I'm sorry, because it's very complicated. But there are some parts of parliamentary procedure that can be helpful when you're running a board meeting, when you're dealing with a difficult owner. So a couple things to remember would be know when to table a motion. So if you're going nowhere on something, and there's a lot of fighting, the board president should say, okay, it sounds to me like we're not going to be able to get through this topic today. Let's table this motion. Let's revisit it again at the May board meeting. Also, refer a matter to a committee if we don't have enough information. A really great thing to do would be to refer it to a committee to have them investigate it further. Maybe put the gadfly on the committee and get them to be busy doing something instead of just fighting with the board. Limit debate. Know when it's time to move on. That's really important because sometimes these meetings, I personally hate it when I'm on two boards. I'm on a regular board and then on a master board. I absolutely despise it when the meeting gets past 2.5 hours. Like I can't stand it. It's horrible. I'm a busy person and I don't want to sit there for more than 2 hours. Really, 2.5 is when I, start getting to the, breaking point almost where I just can't believe the meeting's still going on. So the goal should be an hour board meeting, frankly. Most boards are operating in an 1.5-hour frame, but if you're pushing over to 2 or 2.5 hours, you've got some major dysfunction. And you may want to check out our cheat sheet on, how to have an effective board meeting in an hour or less. Okay, so we've talked a little bit about board member to board member conflict. We've talked about, gadflies and how to deal with the gadfly, right? Remember that when you're dealing with the difficult person, last parting things I'm going to give you would be ask the difficult person to explain exactly what they're upset about in order to show that you're interested in what they're complaining about or the problem is that they see. Listen carefully to what they're saying because there might be some truth in what they're saying. Then after they've explained what they're upset about, agree with anything that's happened that's wrong. Like the management company, I called the management company and they didn't call me back, for 2 weeks. Okay, I'm very sorry that happened. And we will be talking about this with the management company. Our policy is that phone calls need to be returned within, 24 business hours or something. Whatever the policy is, 24 hours, 48 hours. If we've made a mistake, acknowledge it, own it. We're sorry. We will do better. If sometimes somebody goes on attack dog mode against the board, if you need a minute, take a second to compose yourself before responding. Take your time. Don't get emotional. Say we'll look into it if it's something that we need to look into. Ask the owner, what exactly do you want? What do you want the board to do to make this situation better? And that's really telling because they might just say, I just wanted you to apologize and tell me that, this isn't going to happen in the future. Other times they may say, I want money or I want to be reimbursed for this or whatever. And so it's important to anchor what they want, and then we can talk about it as a board and decide, what the best manner is to handle it. Suggest alternatives if we have any, any ideas like, well, this is something that you might be able to do, or, come to more board meetings. We really appreciate you coming here today, but we wish you'd be more involved. Resist the urge to fight. Resist the urge to win. Okay, we're all neighbors. We have to see each other when we're out walking our dogs and our kids. We don't want a bunch of unrest because honestly, that costs a lot of money to your association. So listen, ask questions, ask them what they want, what they're looking for, and then try to make the best possible business decisions. And remember, when you're dealing with these difficult owners, reach out to your trusted advisors, right? If the owner threatens to sue you, what's the first thing you should be thinking? We need to notify our insurance carrier that there's possible, chance of litigation. You have a notice requirement in your insurance policies, so that's something you should be thinking. Reach out to your trusted advisors who are your management company and your attorney, and ask them for suggestions on how to deal with the difficult person. Sometimes the person is so difficult or they have such severe mental illness that this just gets escalated right up to the attorney, and I handle it from there. And I send a letter to the homeowner saying, no more direct communication with the board. All communication needs to be in writing with my office. And that's a very effective way to shut down the gadfly that is so difficult that the board can't manage them anymore, or maybe even somebody who has mental illness. Okay, so I think we've given you some really good tips on, how to handle inter-board conflict, how to handle gadflies in your community. Let's switch gears and talk a little bit about removing a director from office. I find that it's kind of cyclical. Every year we see at least 15 or 20 board removal meetings that are, that occur in our associations that we represent. And I have some really good suggestions. We're going to go over, okay, here's the process. What do you do if this is a sticky situation? What do you do if your board finds out that there's some homeowners that are circulating a removal petition, right? We're going to talk about that. Then I'm going to talk about how do we handle the removal meeting, right? Maybe you're a homeowner that's listening in today and you don't like how your board is handling things and you're considering, proceeding forward with removal of a board member or all the board members. So, we're going to just cover both angles on this. So first, let's talk about removal of directors from office. Just so you're aware, there is a state law that specifically applies to removing a director from office. And it's in the Planned Communities Act. If you're a planned community or HOA, it's Arizona Revised Statutes 33-1813. If you are a condominium, it's 33-1243. This law trumps your documents. So no matter what your bylaws or CC&Rs say about how to remove a director from office, this law trumps it. And basically the Condo Act and the Planned Communities Act mirror each other. So it's the same law basically for both. I want to make a distinction here because there is a difference between a director and an officer, right? So officers of your corporation are the president, vice president, secretary, treasurer. Those officer positions are elected by the board. And typically in your bylaws, you can strip that title, president, vice president, secretary, or treasurer, by a majority board vote. Okay, so that's something that you look to your bylaws for. If you're, electing an officer or removing an officer, that's something that your board does internally and a majority vote rules. This is different. This is for the actual director position, the director at large position. So remember that if you're a president, not only are you an officer, but you also are a director at large. So there's a distinction. So if you want to remove a director from office, and let's say this person happens to be the president, if they successfully get removed, then guess what? They're out as officer president too, because they lost their director position. Okay, so let's talk a little bit about what the law says. Again, this law trumps your documents for removal of directors at large. So if you're under declarant control or developer control, it's important to note that this law does not apply to you. This procedure does not apply to board members appointed by the developer. And like I said, it supersedes or trumps any provision in your documents. So, okay, what's the procedure? If your board is hearing that there is a removal petition circulating in your community, and typically how most boards hear about this is somebody will say to them, gosh, it was so weird. On Sunday, somebody knocked on my door and wanted me to sign something saying that the board isn't doing a good job. That's a warning sign that there's a removal petition brewing in your community. Or maybe they set up an online platform for people to sign saying, please remove the board, from office. This is a petition to remove the board from office. If your board gets wind of that, what I recommend, and this is a very successful strategy, is immediately your board needs to get out there and talk to your owners. And the best way to do that is to have a town hall to air grievances. Now, boards typically don't like doing that because typically town halls sometimes can be a little negative and you might be getting some negative feedback, especially if there's people that are upset and signing a removal petition. But it's the cheapest and best way to shut down a removal petition because it shows people in the community that you care as a board, that you want to listen and you want to do better. And you have to have a meeting with yourself if you're serving on your board and you're hearing that there's a removal petition brewing. Something's not going well. And you need to accept that and figure out a way to move forward. Maybe this is a good time for you to reach out to your trusted advisors and say, that, hey, there's a removal meeting and I think this is what's kind of fueling it. Somebody's upset about, the special assessment or the pickleball noise or whatever the issue is. All the time, clients are reaching out to me, board members saying, hey, this is an issue. We're hearing about this removal. How should we handle it? And the first thing I say is get out there and communicate, whether it's newsletter, having a town hall, amp up your communication so that when people are being approached, with all kinds of negative stories from the gadflies who want the owners to sign the removal petition, the owners aren't going to get involved because they're already in the know. They know the board is doing a good job and they don't want to get involved in any sort of drama with a removal meeting. So that's just a good practice pointer that if you're faced with this problem and you're serving on your board, now is the time to reach out to your trusted advisors and amp up your communication, consider a town hall. Okay, so what happens if the removal petition actually moves forward? So the board is, the homeowners are out there getting people to sign the removal petition. So what exactly qualifies as a valid removal petition? So let's talk about associations with 1,000 or fewer members first. There's two ways to analyze this: 1,000 or fewer, or over 1,000 members. So if you're an association that falls in the category of being 1,000 or fewer members, the petition has to be presented to the board, signed by at least 25% of the eligible votes in the association, or 100 votes in the association, whichever is less. So for example, if you have 100 lots in your association, you would need to have at least 25 signatures on a petition to remove the board. And those 25 lot owners would have to be in good standing. So, you have to check to see what your documents say, but if you're delinquent in assessments, they're not typically going to be able to sign the petition. If they have a violation, it's possible that their petition signature doesn't count. And also it has to be a record owner. So the person has to be listed on the deed, or they have to be a director of a corporation that's listed on the deed, or a trustee of a trust if the property's owned in a trust for estate planning purposes. So 25% or 100 votes if your association is, or 100 signatures if your association has 1,000 or fewer members. If you have over 1,000 members, the petition has to be signed by 10% of the eligible votes, or 1,000 votes, whichever is less. So I think it's always going to be 10%. I don't think we have that many associations in Arizona that have, maybe Sun City West has a lot of members, but so it's probably going to be the 10% if you're over 1,000 members. A couple of things that the board should do when the petition is submitted to the board. Number one, also a great time to amp up communication again. Lots of times the petition is unsuccessful if, let's say, they have the signatures to move forward, and the next step is going to be to have a meeting of the membership to vote on the removal of the board members. But if at this juncture, the board can stop it by amping up their communication, have a town hall, answer questions for people that are upset about it. On occasion, this is a question that comes up often, is sometimes the board gets a petition and they think the signatures were forged. And so the first thing that we do, and this is a suggestion for you as a board, when you get that petition, make sure you get it to your attorney, if you can, the same day the petition comes in. And why is this important? Because you have 30 days to have this removal meeting of the membership. And we have a lot of stuff to do in that 30 days. It's just like planning an annual meeting in 30 days. And so the first thing that I do when our firm gets a removal petition is we ask for a delinquency list, and we look at the petition names and we cross-check with the recorder's office or the assessor's office to see if whoever signed the petition is a record owner. We look for duplicate signatures. Sometimes a husband and a wife sign it. If they both are on the deed, you only get one signature per lot. I can't get too involved in the whole forgery thing because it's going to take too long to investigate. And I don't really know. I don't think I've had this question a lot from boards, but I don't think, other than one time, I don't think I've ever had a situation where there were a lot of names forged by anybody. And so what I typically will suggest to the board, if they think that, like, they called Susie Q and she said she didn't sign it. Or she signed it, but she thought it was to get more pickleball courts, right? If she signed the piece of paper and it says this is to petition to remove the board, if she didn't read it, that's a difficult situation. So typically what we'll do is we'll send out, after getting the petition, if the board is saying that the signatures are forged or people didn't know what they were signing, we'll immediately, like within the day or two of getting the petition, we'll send out a email to the people that signed the petition saying, we received a petition for the removal of the board or select board members. Your name was on the petition as somebody who, was signing to have this petition move forward. If you didn't sign this, please email the attorney and say that you didn't sign it, you want your name removed, or if you've changed your mind, you don't want your name on here anymore because you didn't know what you signed, please let us know right away. I mean, very infrequently does that actually change the fact that, typically they still have the percentage that they need, but the board feels better. At least they reached out to the people and they have some clarity as to, whether or not people's signatures were forged. Okay, so the next thing is, assuming that we have the percentage that we need for the petition to move forward, we have to have a special meeting of the membership within 30 days of that petition date being submitted. And there are some pretty serious repercussions that we're going to talk about in a minute if you don't get that meeting done in 30 days. Basically, if you don't get that meeting done in 30 days, the entire board is removed. So it's very serious. This timeline is hot. Like, you have got to act on this. This is not something you can put in the corner of your desk and wait a week. So we have to give notice of the meeting, and this is going to be the same notice that we would have to give for an annual meeting. So at least 10 days before the meeting, the notice of the meeting and the ballot will need to be mailed out. At the actual meeting for the removal, there's a special quorum. Regardless of what your association documents say, the quorum for this removal meeting is we have to have at least 20% of the votes in the association appear at the meeting in person or by absentee ballot for the meeting to move forward. So, if you have a percentage of people that, sign the petition, you're likely going to get a quorum. So you need to hear that. Unless maybe the board has really amped up their communication and some people that signed the petition maybe changed their mind and they don't want to move forward with it anymore. It's possible that you won't get a quorum. However, my experience of doing this for the past quarter of a century is that this removal meeting is probably one of the most high participation meetings that you'll have in the history of your association. I always call it, it's the social event of the year. People show up. People return their absentee ballot. Typically, they have strong feelings about removing a director or not removing a director from office. At the meeting, you have to have the quorum of 20% of the votes, right? And a member is removed only if a majority of the votes eligible to vote who are voting on the matter at the meeting, vote yes. So you need a majority of the votes, either in person or by absentee ballot, to remove a director from office. So that's the bottom line. And so let's give an example. Let's say, go back to our 100 example. So we had a 100 lot association. We needed the petition to be signed by 25 people, right, that are in good standing and that are record owners. At the removal meeting, we would need at least 20 people, so 20% quorum of 100, to be present in person or by absentee ballot for the meeting to move forward. At that actual meeting, we would need 51 people to vote. Well, let's give an example. Let's say we have 100% attendance, right? So we would need 51 people out of 100 to vote yes for the removal for it to move forward. Let's give an example. Let's say maybe only 50 out of the 100 come. We would need 26 people to be present at that meeting. 20 people present at the meeting, and then 26, that'd be a majority, 26 out of 50 would need to vote yes to remove the directors from office. Now, from my experience of doing this quarter of a century, I can tell you that most boards are not removed from office, whether it's one board member or the entire board. Why? Because people don't want your job. They don't. It's a hassle being on the board, right? It's a lot of work. What they want is they want the board to hear that they're not happy, and they want the board to change course. And so again, amping up that communication and listening and acknowledging that maybe something didn't go as well as we wanted it to, it might avert you from being removed from office. And some board members, once they get the removal petition, they say, I'm out of here. I quit. That happens from time to time too. But most boards, I would say, they are on the board for the right reason. 99% of the boards, we're all voluntary because we want our associations to be better. And frankly, we don't want to get removed. I mean, that's embarrassing, right? I wouldn't want that to happen to me. And I would have to have honest feedback is good for everybody. And the honest feedback is, hey, things aren't going well. 25% of our owners aren't happy. We need to make some changes as a board, and we need to listen, and we need to acknowledge that we're going to do better going forward. If you do that, you will not be removed. But if you want to go down, like a kamikaze plane, the way that you do it is you don't acknowledge that there's problems. You tell them you're not changing how you're behaving. You don't listen. That's a good way to get removed. And also another add-on would be if you're just not nice, if you're rude to people and don't treat people in a business-like manner. I mean, it's like almost 10 for 10, 100% chance you're going to get removed. Okay, a couple things to remember. If you go through this removal meeting, after their meeting is conducted, we have to keep all the records for at least a year after the special meeting. And if anybody wants to review them, any homeowner, they're entitled to review them. Only one removal attempt per term. So if there's a removal petition submitted for me, I think I have maybe a year left on my term right now for my board. And they try to remove me in April of 2024 and I don't get removed, they can't come back in December of 2024 and try again. So it's only one removal attempt per term. A couple of other things to remember are a couple changes in the law over the years have been that if fewer than a majority of the members of the board are removed at a removal meeting. So let's give an example. If you have a 5-member board and let's say 2 are removed at a removal meeting, what happens is the positions become vacant, right? And then the vacancies can be filled pursuant to the association's documents. So typically what that means is that the existing board, those 3 board members, can appoint the vacant positions. If a majority of the board members or all of the board is removed, then you want to look at the association is probably going to have to hold an election for the replacement of those directors. Typically, the management company, maybe your attorney, will handle that because the board's out, right? A majority of the board's out. So we have to step in and assist with that. Don't forget about the new law that went into effect last year or the year before that says that if you don't conduct this removal meeting within 30 days of getting the petition, the board is removed from office. So just remember that is a very hard deadline and there is no way around that. We have a cheat sheet for you too, just to kind of help out if you have any like code of conduct issues for your board. I'm just throwing this as an add-on. I just thought of it that I thought would be something that would be good and helpful. We have a cheat sheet that talks about, a code of conduct for the board. If you're having internal problems on your board, this is a good reference point for you. Okay, let's talk a little bit about our last topic today. Sticky situation is how to prevent theft and fraud in associations. Just in the past quarter, right? So in the first 3 months of 2024 and an extra month right now, we've seen in the news 3 different examples of fraud and embezzlement in associations. And so I think it's a sticky topic. It's a scary topic. And so I just want to talk a little bit about this because it's a difficult situation. If your association gets into any of these situations, right? All of these things equal money out the door for your association, whether it's difficult owners or fighting between the board. You're going to spend a lot of money navigating that issue, whether it's with lawsuits or with paying attorney's fees, etc. Same thing about a removal meeting for the board. I mean, those are really expensive. I've seen you cannot get out of a removal meeting without spending at least $5,000 in attorney's fees. Okay. I've seen some removal meetings with litigation afterwards and the whole deal have gone all the way up to $80,000, $80,000. That's crazy. This topic of, theft and fraud of association funds, we've seen, petty theft of, just like petty cash missing, but we've seen cases over the years of hundreds of thousands of dollars up to millions of dollars. All you have to do is Google HOA, Arizona, and fraud or theft of association funds. And you're going to see over the past 20 years, there's plenty of examples of this occurring in our own state. So I want to just take a quick minute in, like the last 5 minutes before we get into the questions and talk about how do we prevent this, right? How do we stop this from happening in your association? Well, let's talk about what it looks like so that you can recognize it if this is happening in your association. So what does, fraud or misappropriation look like? So misappropriation of funds typically is going to look like outright taking of cash. So they're just stealing the petty cash with no backup documentation. So they're using the credit card, for the association, which I think is a very bad idea. Mind you, I do not think you should have a credit card for your association. I just think it's too much opportunity for somebody to misuse it. Faked expenses. Maybe they submit a bill for something that was never done. Maybe non-existent employees are being paid on a payroll. Transferring association funds to another community, the management company or the manager without authorization shouldn't be happening. Use of association funds as collateral on a personal loan. We've seen that. Look it up in the news, where a manager or somebody in the management company claims that the bank account is somehow theirs and they're getting a loan for their house, claiming, that the association's funds are their collateral. Showing investments on a financial statement, but they don't even exist. We just saw this just recently where an association had a reserve account and, they changed management companies and the new management company never set up the association's reserve account. They took the money somewhere else and it's gone. And so these type of things do happen. So you've got to be carefully checking, we're going to talk about how to prevent it. So I'm scaring you right now with all the different things that can happen. And then we're going to talk about what are some solutions. Another example would be the manager paying their personal bills with association funds. So it looks like the check is being paid to SRP, but it's actually not the SRP bill for the association. It's the manager's SRP bill or the board member's SRP bill. So the treasurer needs to be carefully looking at every invoice, with the bills. What are some signs of fraud? Missing bank statements and reconciliations. So maybe the treasurer or the management company is way behind in giving us the financials. That's a warning sign right there. General ledgers that aren't balancing. Missing and altered documents. Photocopies of everything, not originals. Unexplained cash shortages. We're desperate for cash. Something's due tomorrow. We don't have enough money. Can I have authority to transfer funds? I mean, that should not be happening in your association, right? Unauthorized credits to receivable accounts, increased past due accounts, NSF charges for your bank, duplicate payments to vendors. That's another way to do it. Unexplained overdraft, other bank charges, unauthorized purchase transactions, and payments for unspecified services. So what are some things that you can do as a board, to prevent this from happening, right? First, you should have a good insurance policy. So make sure when you renew your insurance every year that you have a fidelity bond. Make sure that you are named as an additional insured on your management company's insurance policy and that they have adequate, insurance in the event one of their employees takes money from the association. And be vigilant and take control of the situation. And here's our recommendations for you as an association so that this never happens to you. Keep the association's records up to date. So don't fall behind on financial statements, budget, year-to-date budget reconciliations. You should be getting a financial report of the association every month, even if you're not having a meeting for your association. Make sure the reserve account, which is traditionally where you have all your money for the association, your big, large chunk of money for long-term capital improvements. Sometimes it's over $1 million. Make sure control of the reserve account is in the name of the board and that all board members only can remove money from the reserve account. Not one person, not the management company. That account should never be in the name of the management company. It should only be in the name of the association, and all of the boards collectively, all the board members collectively, sign off with meeting minutes to transfer money out of the reserve account. Monthly financial reports should be made available for the board. And in that monthly report, it should be a balance sheet, a statement of revenues and expenses, a year-to-date budget, copies of the bank statements, copies of your CDs, maybe a summary of when CDs become due. Also, you should be making sure that you have your, money in FDIC insured banks and that you don't have over the FDIC insurance, limits, so that in the event the bank goes under, you have an insurance by the FDIC to cover any deposits that you have in that bank. I get a lot of slack for saying this, but I'm going to say it anyways. Get 2 signatures, at least from at least one board member, but preferably 2 board members on all checks or transfers greater than a pre-designated amount. So maybe what you say to the management company is, okay, you can pay our regular bills, like the management company bill, the landscaping bill, the electric bill, the pool company, but any other bills that are over a certain amount need to have 2 board signatures. Our association does that. We actually sign every check. 2 board members sign every check. I would be lying to you if I didn't tell you it is a hassle because every Friday I have to sign checks. But it gives me great comfort knowing that I'm looking very carefully at every invoice when I'm paying the check, signing the check. And also the treasurer of our association is doing the same thing. So we have 2 layers of insulation. Again, another comment is whoever's signing the checks, make sure you're looking at the invoices and the supporting documentation to make sure that it's the association's bill. And look for anything weird like late fees or, it's addresses that aren't, part of your association, etc. Review the bank statements and reconciliations every month. The treasurer has a heightened review. I would say at least 30 minutes of financial review for the treasurer every month. Other board members spend 5 to 10 minutes looking through it as you prepare for the board meeting. Petty cash. Don't have $5,000 in petty cash sitting around. That's not a good idea. Keep it a small amount and have it in a secure place and have a procedure for keeping track of the petty cash, a written procedure, and have an update on that every month at the board meeting. How much money was spent, have a copy of the written, the written withdrawals from that, and that's provided as part of your board packet. Take a peek every month at your delinquent receivables balances and keep an eye on those. Make sure you, again, I said this already, but this is kind of, a really good thing that I want to remind everybody of. Make sure that you have fidelity insurance or fidelity bond as an association to cover the volunteers and the employees who handle association funds as well as board members. In addition, arrange for D&O coverage, directors and officers coverage in the event the entire board is accused of financial mismanagement. Your association should be having an audit review or a compilation every year under Arizona of the association's financial records. And so we really recommend that be done by a CPA. If your association can't afford that, what you might want to do is take 3 years of records to the CPA and have them randomly audit 1 year, so you don't know what year. You have to use a CPA to audit your records if your documents for your association require that, and there's no way around that. You have to do that. The last parting point would be if your board discovers that funds are missing. It's really scary. I can tell you I have been through this process with a number of boards. Unfortunately, I went through it with my association. When I got back on my board, there was an issue with prior manager. I had taken some money from the association. It's scary. It's not something you can sweep under the rug. So the best advice I can give you is if you're in this situation, remove the suspected fraud perpetrator from the position of control. So if it's, an employee of the management company, you need to be in direct communication with the president of the management company. Make sure that that person is nowhere near your funds. If it's a treasurer for your association, you need to have a meeting immediately of your board, and you need to strip that treasurer of their title and put somebody else in control of the funds. Go to the bank, get everything changed to make sure that person has no access to the funds. Put a stop on all bank activity. Notify your insurance carrier. And most importantly, first call should be to your association attorney to strategize with you. It's the best way to handle this situation. I'm so happy to say that I can't believe it. We had 183 live viewers on Zoom. That is amazing. Thank you so much, everybody, for being here. And many more with us on Facebook Live. So what a great turnout. I think what this probably means is that a lot of you are dealing with a lot of different sticky situations in your association. If there's anything that you'd like us to talk about in the future on a class like this, talking about what are difficult situations for an association, if you can, I'd like you to put it in the chat right now, and we will consider that for future classes, either on the comment section on Facebook Live or in the chat on Zoom. We're always looking for feedback for classes that's going to contain information that you want, that you need as board members or homeowners or managers in our industry. Don't forget that our firm's next virtual First Friday event is May 3rd, Friday, May 3rd at 9 a.m. Hope you will join us for that. And that procedure for that is you get to ask questions and I provide answers for free, 1 question per person. Finally, I hope you'll be back here next month. How is it already May? It's shocking to me that we're already in May. On Tuesday, May 21st for class number 5 of our 2024 Virtual HOA Condominium class. Condominium Academy class, and we're going to be talking about a comprehensive guide to board roles and responsibilities. So we're going to tell you the skinny on everything you need to know if you're serving on your board, to keep you out of trouble, to help you be productive, and to follow the law in your documents. So we hope that you will join us for that class on Tuesday, May 21st at 11 a.m. on Zoom. So thank you, everybody, for being here today. We appreciate you and hope you have a great rest of the month. Take care. Bye.